Part 4 Relatives. Chapter I General Provision. Article 767. Definition of relatives. A spouse, blood relatives and relatives by affinity shall be considered as relatives. Article 768. Definition of blood relatives. One's lineal ascendants and lineal descendants shall be one's lineal blood relatives. One's brothers and sisters lineal descendants, brothers and sisters of one's lineal ascendants and such brothers and sisters lineal descendants shall be considered collateral blood relatives. Less than amended by Act No. 4199, January 13, 1990. Greater than. Article 769. Lineal of relatives by affinity. Spouses of blood relatives of the spouse, and spouses of the blood relatives of the spouse shall be relatives by affinity. Less than amended by Act No. 4199, January 13, 1990. Greater than. Article 770. Computation of degree of relationship of blood relatives. 1. The number of generations of a lineal blood relative shall be determined by computing the number of generations ascending from the person concerned to his or her ascendant or descending from him or her to his or her descendant. 2. The degree of relationship of a collateral blood relative shall be determined by computing the number of generations ascending from the person concerned to a lineal ascendant of common origin and then descending from such lineal ascendants of common origin to his or her lineal descendant. Article 771. Calculation of degrees of affinity. The affinity shall be determined by the degrees to blood relatives from the spouse for blood relatives of the spouse, and those to the blood relative for the spouse of a blood relative. This article wholly amended by Act No. 4199, January 13, 1990. Article 772. Parental lineage and degree of relationship of adopted child. 1. Parental lineage and the degree of relationship between an adopted child on the one hand and the parent by adoption and their blood relatives and relatives by affinity on the other, shall be deemed from the time when an adoption has been made, the same as those of a child born while the father and mother are in matrimonial relations. 2. The degree of relationship of the spouse, lineal descendant and the spouse of such lineal descendant, of the adopted child shall be determined upon the basis of the parental lineage of an adopted child as prescribed in paragraph 1. Articles 773 and 774 deleted. Less than by Act No. 4199, January 13, 1990. Greater than. Article 775. Extinction of affinity relation, etc. 1. Affinity shall be terminated by annulment of marriage or divorce. Less than amended by Act No. 4199, January 13, 1990. Greater than. 2. In cases where one of husband and wife has died, if the surviving spouse has remarried, the provisions of paragraph 1 shall also be applicable. Less than amended by Act No. 4199, January 13, 1990. Greater than. Article 776. Extinction of relationship by adoption. Relationships arising due to adoption shall be terminated by annulment or dissolution of the adoptive relationship. Article 777. Scope of relatives. Legal effect taken by relationship of relatives shall extend to the following persons unless this act or other acts provide otherwise. 1. Blood relatives within the 8th degree of relationship. 2. Affinity relatives within the 4th degree of relationship, and 3. Spouse. This article wholly amended by Act No. 4199, January 13, 1990. Chapter 2 Scope of Family Members and Surname and Origin of Surname of Child. Article 778 deleted. Less than by Act No. 7427, March 31, 2005 greater than. Less than this article was deleted by Act No. 7427, March 31, 2005, pursuant to the decision of incompatibility with the Constitution which was made by the Constitutional Court on March 27, 1997 greater than. Article 779, Scope of Family Members. 1. Family members shall consist of the following persons. 1. The spouse, lineal blood relatives, and brothers and sisters, and 2. Spouses of the lineal blood relatives of the spouse, and brothers and sisters of the spouse. 2. In the case of paragraph 1-2, it shall be limited to the case where they share living accommodations. This article wholly amended by Act No. 7427, March 31, 2005. Article 780 deleted. Less than by Act No. 7427, March 31, 2005 greater than. Article 781, Surname and Origin of Surname of Child. 1. A child shall succeed his or her father's surname and origin of surname, provided that when the parents agree to have the child assume his or her mother's surname and origin of surname at the time of filing a report on their marriage, he or she shall succeed the mother's surname and origin of surname. Less than this portion, child shall succeed his or her father's surname and origin of surname, in this paragraph was amended by Act No. 7427, March 31, 2005, enforced on January 1, 2008, pursuant to the decision of incompatibility with the Constitution which was made by the Constitutional Court on December 22, 2005 greater than. 2. Where the father is a foreigner, the child may succeed the mother's surname and origin of surname. 3. A child whose father is not known shall assume the mother's surname and origin of surname. 4. A child whose father and mother are not known shall, with the approval of the court, establish a new surname and origin of surname, provided that if the father or mother is known after the child has established a new surname and origin of surname, the child may assume the father or mother's surname and origin of surname. 5. Where a child born out of wedlock is affiliated, the child may continue to use the previous surname and origin of surname subject to the agreement of the parents, provided that if the parents cannot make such an agreement or fail to reach such an agreement, the child may continue to use the previous surname and origin of surname with the approval of the court. 6. Where there exists a need to alter the surname and origin of surname of a child for the welfare of the child, they may be altered with the approval thereof which the court grants upon a request of the father or mother or the child itself, provided that if the child is a minor and its legal representative may not make such a request, the request may be made by the relative provided for in Article 777 or a public prosecutor. This article wholly amended by Act No. 7427, March 31, 2005. Articles 782 through 789 deleted. Less than by Act No. 7427, March 31, 2005 greater than. Article 790 deleted. Less than by Act No. 4199, January 13, 1990 greater than. Article 791 deleted. Less than by Act No. 7427, March 31, 2005 greater than. Article 792 deleted. Less than by Act No. 4199, January 13, 1990 greater than. Articles 793 through 796 deleted. less than by Act Number 7427, March 31, 2005, greater than. Articles 797 through 799 deleted. Less than by Act Number 4199, January 13, 1990, greater than. Chapter 3, Marriage. Section 1, Matrimonial Engagement. Article 800. Freedom of matrimonial engagement. Any adult person may freely enter into a matrimonial engagement. Article 801. Eligible age for matrimonial engagement. Any person who has attained the age of the 18th of May enter into a matrimonial engagement upon the consent of his/her parents or adult guardian. Article 808 shall apply mutatis mutandis to such cases. This article wholly amended by Act Number 10429, March 7, 2011. Article 802. Adult guardianship and matrimonial engagement. An adult ward may enter into a matrimonial engagement upon the consent of his/her parents or adult guardian. Article 808 shall apply mutatis mutandis to such cases. This article wholly amended by Act Number 10429, March 7, 2011. Article 803. Prohibition of compulsory performance of matrimonial engagement. No person may claim to the court for compulsory performance of a matrimonial engagement. Article 804. Causes for dissolution of matrimonial engagement. Where any of the following causes is attributable to any one party to a matrimonial engagement, the other party may dissolve such engagement. 1. If one of the parties has been sentenced to punishment of suspension of qualification or heavier punishment. 2. If one of the parties has been adjudicated to commence adult guardianship or limited guardianship after the conclusion of matrimonial engagement. 3. If one of the parties has been suffering from a venereal disease, incurable psychosis, or any other incurable disease. 4. If one of the parties is engaged to or has married a person other than the party to the engagement after the conclusion of matrimonial engagement. 5. If one of the parties has committed adultery with another person after the conclusion of matrimonial engagement. 6. If the death and life of one of the parties has been unknown for at least 1 year after the conclusion of matrimonial engagement. 7. If one of the parties has refused or delayed marriage without a just ground. 8. If any other serious cause arises. This article wholly amended by Act Number 10429, March 7, 2011. Article 805. Method of dissolution of matrimonial engagement. Dissolution of a matrimonial engagement shall be effected by the declaration of intention of one party to the other party, provided that where a party is unable to make any declaration of intention to the other party, such engagement shall be deemed to have been dissolved when the cause of such dissolution becomes known to the dissolving party. Article 806. Dissolution of matrimonial engagement and claims for damages. 1. When a matrimonial engagement has been dissolved between parties, one party may claim against the other party in negligence the damages therefrom. 2. In paragraph 1, the negligent party shall be liable for damages from mental anguish in addition to property damages. 3. Claims for damages from mental anguish may not be assigned or succeeded, provided that this shall not apply to the case where a contract concerning indemnity has already been entered into between the parties or a legal action on a claim for damages has been instituted. Section 2. Formation of marriage. Article 807. Marriageable age. Any person who is 18 years old or older may enter into matrimony. This article wholly amended by Act No. 8720, December 21, 2007. Article 808, Marriage requiring consent. 1. A minor shall obtain the consent of both parents in order to marry. If one parent is unable to exercise the right of consent, the minor shall obtain the consent of the other parent, and if neither parent is able to exercise the right of consent, the minor shall obtain the consent of his/her guardian of minor. 2. An adult ward may marry upon obtaining the consent of his/her parents or adult guardian. This article wholly amended by Act No. 0429, March 7, 2011. Article 809, Prohibition of consanguineous marriage, etc. 1. A marriage may not be allowed between blood relatives, including the blood relatives of an adoptee before full adoption, within the 8th degree of relationship. Less than this paragraph was amended by Act No. 7427, March 31, 2005 pursuant to the decision of incompatibility with the Constitution which was made by the Constitutional Court on March 27, 1997 greater than. 2. A marriage may not be allowed between the parties who are or were such relatives by affinity as the spouses of blood relatives within the 6th degree of relationship, the blood relatives of the spouse within the 6th degree of relationship, and the spouses of blood relatives of the spouse within the 4th degree of relationship. 3. A marriage may not be allowed between the parties who are the blood relatives of adoptive parent line within the 6th degree of relationship and the affinity relatives of adoptive parent line within the 4th degree of relationship. This article wholly amended by Act No. 7427, March 31, 2005. Article 810, Prohibition of bigamy. No one who has a spouse shall enter into another marriage. Article 811 deleted. Less than by Act No. 7427, March 31, 2005 greater than. Article 812, Formation of marriage. 1. A marriage shall take effect by reporting in accordance with the provisions of the Act on the Registration, etc. of Family Relationship. Less than amended by Act No. 8435, May 17, 2007 greater than. 2. The report mentioned in paragraph 1 shall be submitted in writing with co-signatures of both parties and 2 adult witnesses. Article 813, Examination of Marriage Report. Marriage report shall be accepted unless a marriage is in violation of the provisions of Articles 807 through 810 and 812, 2, and of any other acts and subordinate statutes. Less than amended by Act No. 7427, March 31, 2005 greater than. Article 814, Marriage Report in Foreign State. 1. A marriage between Korean nationals in a foreign state may be reported to the Korean ambassador, minister, or consul stationed in that state. 2. The ambassador, minister, or consul who has received such a report, as mentioned in paragraph 1, shall promptly forward such a report and any other documents attached thereto to the family registration offices in the home state which have jurisdiction over the place of registration of the nationals concerned. Less than amended by Act No. 7427, March 31, 2005, Act No. 8435, May 17, 2007 greater than. Section 3 Nullity and annulment of marriage. Article 815, Nullity of marriage. A marriage is null and void if it falls under any one of the following subparagraphs. Less than amended by Act No. 7427, March 31, 2005 greater than. 1. Where there is no agreement to marry between the parties. 2. Where the marriage is in violation of Article 809, 1. 3. Where there exists or existed between the parties the relationship of lineal relatives by affinity, and 4. Where there existed between the parties the relationship of lineal blood relatives of adoptive parent line. Article 816. Causes for annulment of marriage. A claim to the court for annulment of a marriage may be made under any one of the following subparagraphs. Less than amended by Act No. 4199, January 13, 1990. Act No. 7427, March 31, 2005 greater than 1. Where a marriage is in violation of the provisions of Articles 807 through 809, excluding the cases falling under the nullity of marriage under Article 815. Hereafter in Articles 817 and 820 the same shall apply, or 810. 2. When at the time of marriage one of the parties was unaware that the other party had been suffering from a malignant disease or had any other serious reason which would make marital life unable to continue, and 3. When the declaration of intention to marry has been made by fraud or duress. Article 817. Claimant for annulment of marriage in violation of marriageable age, etc. In the case of a marriage in violation of the provisions of Articles 807 and 808, a claim for annulment of the marriage to the court may be made by either party or legal representative thereof. In case of a marriage in violation of the provisions of Article 809, a claim for annulment of the marriage to the court may be made by either party, their lineal ascendants or collateral blood relatives within the fourth degree of relationship. Less than amended by Act No. 7427, March 31, 2005 greater than. Article 818. Claimant for annulment of bigamy. The principal, his/her spouse, lineal ascendants, collateral blood relatives within the fourth degree of relationship, or a public prosecutor may make a claim to the court for the annulment of a marriage, if it is in violation of Article 810. This article wholly amended by Act No. 11300, February 10, 2012. Article 819. Extinction of right of claim for annulment of marriage without consent. In cases of a marriage in violation of Article 808, no claim for annulment of the marriage may be made, if 3 months have elapsed from the day the minor party has attained the age of 19 or the termination of adult guardianship has been adjudged, or if the female party has become pregnant during the marriage. This article wholly amended by Act No. 10429, March 7, 2011. Article 820. Extinction of right of claim for annulment of consanguineous marriage, etc. In cases of a marriage in violation of the provisions of Article 809, no claim for annulment of the marriage may be made, if the female party has become pregnant during the marriage. Less than amended by Act No. 7427, March 31, 2005 greater than. Article 821 deleted. Less than by Act No. 7427, March 31, 2005 greater than. Article 822. Extinction of right of claim for annulment of marriage due to malignant disease, etc. No claim for annulment of a marriage may be made on the ground of causes falling under the provisions of subparagraph 2 of Article 816. If 6 months have elapsed from the day when one party became aware that the other party had such cause. Article 823. Extinction of right of claim for annulment of marriage by fraud or duress. No claim for annulment of a marriage by fraud or duress may be made, if 3 months have elapsed from the day when the party discovered the fraud, or became free from the duress. Article 824. Effect of annulment of marriage. The annulment of a marriage shall not be retrospectively effective. Article 824-2. annulment of marriage, fosterage of children, etc. Articles 837 and 837-2 shall apply mutatis mutandis to the responsibility for fostering children and the visitation right in cases of the annulment of a marriage. This article newly inserted by Act No. 7427, March 31, 2005. Article 825, annulment of marriage and right to claim damages. The provisions of Article 806 shall apply mutatis mutandis in a case of the nullity and annulment of a marriage. Section 4 Effect of marriage. Subsection 1 General effect. Article 826, Duties of husband and wife. 1. Husband and wife shall live together, and shall support, and aid each other, provided that both parties must tolerate, if they do not live together temporarily for a due reason. 2. The place where husband and wife reside shall be determined by an agreement between them, provided that if they fail to reach an agreement, the place shall be determined by the family court upon a request of either party. Less than amended by Act No. 4199, January 13, 1990. Greater than. 3. And 4. Deleted. Less than by Act No. 7427, March 31, 2005. Greater than. Less than paragraph 3 was deleted by Act No. 7427, March 31, 2005 pursuant to the decision of incompatibility with the Constitution which was made by the Constitutional Court on March 27, 1997. Greater than. Article 826-2, Attaining majority by marriage. If a minor enters into marriage, he shall be deemed to have attained majority. This article newly inserted by Act No. 3051, December 31, 1977. Article 827, Right of representation between husband and wife for home affairs. 1. Husband and wife shall exercise the right of representation for each other on normal home affairs. 2. Restriction upon the right of representation as mentioned in paragraph 1 shall not be set up against a third party acting in good faith. Article 828 deleted. Less than by Act No. 11300, February 10, 2012. Greater than. Subsection 2 Effect on property. Article 829, Agreement and its alteration on matrimonial property. 1. If husband and wife have not, prior to the formation of marriage, entered into a contract which provides otherwise with respect to their property relation shall be governed by the provision of each article of this subsection. 2. If husband and wife have, prior to the formation of marriage, entered into a contract with respect to their property, such contract may not be altered during the marriage, provided that if there is a due reason to alter such contract, it may be altered upon approval of the court. 3. If, where one spouse manages the property of the other in accordance with the contract referred to in paragraph 2, and such property is imperiled by mismanagement, the other spouse may claim to the court for permission of its own management. In this case, if such property is common property between husband and wife, the other spouse may claim to the court for the division of such property. 4. If husband and wife have entered into a contract regarding their property, such contract may not be enforced against a successor in title of the husband or wife or a third party unless it is registered prior to the formation of their marriage. 5. If the manager has been changed or a division of property in co-ownership has been effected in accordance with paragraphs 2 and 3, or by a contract, such change or division may not be enforced against a successor in title of the husband or wife or against a third party unless it has been registered. Article 830, Peculiar property and property of which title is uncertain. 1. Inherent property belonging to either husband or wife from the time before the marriage and property acquired during the marriage in his or her own name shall constitute his or her peculiar property. 2. Any property, of which title is uncertain between the husband and wife, shall be presumed to be in their co-ownership. Less than amended by Act No. 3051, December 31, 1977. Greater than. Article 831, Management, etc. of peculiar property. Husband or wife shall separately manage, use and take profit from his or her peculiar property. Article 832, Joint liability for obligations with respect to home affairs. If, with respect to normal home affairs, one spouse has effected a juristic act with a third person, the other spouse shall be jointly and severally liable for the obligation therefrom, provided that this shall not apply where a previous notice, to the effect that the other spouse will not assume such liability, has been clearly given to the third person. Article 833, Living expenses. The expenses necessary for communal life of husband and wife shall be jointly and severally borne by them, unless a special stipulation has been made between them. This article wholly amended by Act No. 4199, January 13, 1990. Section 5. Divorce. Subsection 1. Divorce by agreement. Article 834, Divorce by agreement. Husband and wife may get a divorce by agreement. Article 835, Adult guardianship and divorce by agreement. Article 808, 2, shall apply mutatis mutandis to a divorce by agreement for an adult ward. This article wholly amended by Act No. 10429, March 7, 2011. Article 836, Taking effect of divorce and method of reporting. 1. Divorce by agreement shall take effect upon reporting in accordance with the Act on the registration, etc. of family relationship after obtaining the confirmation of the family court. Less than amended by Act No. 3051, December 31, 1977. Act No. 8435, May 17, 2007. Greater than. 2. The report as mentioned in paragraph 1 shall be filed in writing with joint signatures of both parties and 2 adult witnesses. Article 836-2, Procedure of divorce. 1. Any person who intends to get a divorce by agreement shall have a guidance on divorce provided by the family court and, if necessary, the family court may recommend to take counsel with a professional counselor who has expertise and experiences in counseling. 2. The party who filed an application for the confirmation of intention to divorce with the family court may have the confirmation of intention to divorce after the periods, prescribed by the following subparagraphs, have passed since the day of having such guidance referred to in paragraph 1. 1. 3 months, if the party has any child to take care of, including an unborn child. Hereafter the same shall apply in this article, or 2. 1 month, if not falling under subparagraph 1. 3. The family court may exempt the party from or reduce the period under paragraph 2, when there are such urgent circumstances to proceed a divorce as the party's unbearable suffering may be expected due to domestic violence. 4. The party who has any child to take care of shall submit the documents of agreement on fostering under Article 837 and decision of custody under Article 909, 4, or the original copy of adjudication of the family court under Articles 837 and 909, 4. 5. The family court shall establish a child support order to confirm the details of child support agreed between parties. In such cases, with respect to the effect of the child support order, Article 41 of the Family Litigation Act shall apply mutatis mutandis. Less than newly inserted by Act No. 9650, May 8, 2009 greater than. This article newly inserted by Act Number 8720, December 21, 2007. Article 837, Divorce and Responsibility of Fostering Children. 1. The parties shall determine by agreement matters concerning fostering their children. Less than amended by Act Number 4199, January 13, 1990 greater than. 2. If the agreement as set forth in paragraph 1 shall include matters as follows. Less than amended by Act Number 8720, December 21, 2007 greater than. 1. Decision on the custodian. 2. Child support, and 3. Visitation right and methods thereof. 3. Where the agreement as set forth in paragraph 1 harms children's welfare, the family court shall order correction or decide ex officio matters related to fostering, taking consideration of children's intention and age, each parent's financial status and other circumstances. Less than amended by Act Number 8720, December 21, 2007 greater than. 4. Where the agreement on fostering cannot or would not be made, the family court shall decide it upon a request of the party or ex officio. In such cases, the family court shall take matters as set forth in paragraph 3 into account. Less than newly inserted by Act Number 8720, December 21, 2007 greater than. 5. Where deemed necessary for children's welfare, the family court may change matters concerning fostering or take other appropriate measures, upon a request of each parent, children or prosecutor or ex officio. Less than newly inserted by Act Number 8720, December 21, 2007 greater than. 6. Except for matters related to fostering, the provisions of paragraphs 3 through 5 shall not change the rights and duties of parents. Less than newly inserted by Act Number 8720, December 21, 2007 greater than. Article 837-2, Visitation Rights. 1. A parent who does not take care of children and his/her children shall have the visitation right. Less than amended by Act Number 8720, December 21, 2007 greater than. 2. If it is required for the welfare of children, the family court may, upon a request of the party or ex officio, restrict or exclude such visitation right. Less than amended by Act Number 7427, March 31, 2005 greater than. This article newly inserted by Act Number 4199, January 13, 1990. Article 838. Claims for revocation of divorce by fraud and duress. Any person who has declared intention of divorce by fraud or duress may claim to the family court for revocation of divorce. Less than amended by Act Number 4199, January 13, 1990 greater than. Article 839. Provisions to be applied mutatis mutandis. The provisions of Article 823 shall apply mutatis mutandis to the cases of divorce by agreement. Article 839-2. Claim for division of property. 1. One of the parties who have been divorced by agreement may claim a division of property against the other party. 2. If no agreement is made for a division of property as referred to in paragraph 1, or if it is impossible to reach an agreement, the family court shall, upon a request of the parties, determine the amount and method of division, considering the amount of property acquired by cooperation of both parties and other circumstances. 3. The claim for division of property as referred to in paragraph 1 shall be extinguished after 2 years have passed from the date of divorce. This article newly inserted by Act Number 4199, January 13, 1990. Article 839-3. Right to revoke fraudulent act for preservation of claim for division of property. 1. When a party files a legal act for a property right, knowing that such act may obstruct the other party's exercise of a claim for division of property, the other party may file a lawsuit demanding a revocation of such act and recovery therefrom with the family court with Article 406, 1, applied mutatis mutandis. 2. Such lawsuits as set forth in paragraph 1 shall be filed within the period as set forth in Article 406, 2. This article newly inserted by Act No. 8720, December 21, 2007. Subsection 2 Judicial Divorce. Article 840. Causes for judicial divorce. Either husband or wife may apply to the family court for a divorce in each case of the following subparagraphs, less than amended by Act No. 4199, January 13, 1990 greater than 1. If the other spouse has committed an act of unchastity. 2. If one spouse has been maliciously deserted by the other spouse. 3. If one spouse has been extremely maltreated by the other spouse or his or her lineal ascendants. 4. If one spouse's lineal ascendant has been extremely maltreated by the other spouse. 5. If the death or life of the other spouse has been unknown for 3 years, and 6. If there exists any other serious cause for making it difficult to continue the marriage. Article 841. Extinction of right to apply for divorce due to unchastity. With respect to the cause mentioned in subparagraph 1 of Article 840, if the spouse has given a previous consent or an ex post facto tolerance to the other party, or if 6 months have passed since the spouse was aware of such act of unchastity of the other, or if 2 years have passed since the happening of such event, the spouse may not apply to the court for a divorce. Article 842. Extinction of right to apply for divorce due to any other reason. With respect to the cause as provided in subparagraph 6 of Article 840, one spouse may not apply to the court for divorce after the lapse of 6 months since the day when the spouse became aware of such cause, or after the lapse of 2 years since such cause has occurred. Article 843. Provisions to be applied mutatis mutandis. Article 806 shall apply mutatis mutandis to the claims for damages from a judicial divorce. Article 837 to the responsibility of parenting children following a judicial divorce. Article 837-2 to the visitation rights following a judicial divorce. Article 839-2 to the claim for division of property following a judicial divorce. And Article 839-3 to the right to cancel a fraudulent act for the purpose of preserving the claims for division of property following judicial divorce. This article wholly amended by Act No. 11300, February 10, 2012. Chapter IV Parents and Children. Section 1 Children of natural parent. Article 844. Presumption as husband's child. 1. A child conceived by a wife during the marriage shall be presumed to be the child of the wife's husband. 2. A child born after 200 days from the day when the marriage was formed or born within 300 days from the day when the matrimonial relation was terminated, shall be presumed to have been conceived during the marriage. Article 845. Determination of paternity by court. If a woman who has remarried gives birth to a child, and it is impossible to determine the father of the child in accordance with the provisions of Article 844, the court shall, upon the application of the party concerned, determine the paternity of the child. Less than amended by Act No. 7427, March 31, 2005 greater than. Article 846. Denial of paternity of child. Either of husband and wife may, in any case mentioned in Article 844, bring an action to deny that he is the natural father of the child. less than amended by Act No. 7427, March 31, 2005 greater than. Article 847, Action of Denial of Paternity. 1. The action of denial of paternity shall be brought by the husband or wife against the other spouse or the child within 2 years from the day when he or she becomes aware of the cause of the action. Less than this paragraph is amended by Act No. 7427, March 31, 2005 pursuant to the decision of incompatibility with the Constitution which was made by the Constitutional Court on March 27, 1997 greater than. 2. In the case of paragraph 1, if both of the other spouse and the child against whom the action is to be brought has died, the action of denial of paternity may be brought against a public prosecutor within 2 years from the day on which he or she becomes aware of the death. This article wholly amended by Act No. 7427, March 31, 2005. Article 848, Adult Guardianship and Action of Denial of Paternity. 1. If either of the husband or wife is an adult ward, his/her adult guardian may, upon the consent of the supervisor of adult guardianship, bring an action of denial of paternity of a child. If he/she has no supervisor of guardianship or fails to obtain the supervisor's consent, he/she may request the family court to grant an approval substituting for such consent. 2. In cases following paragraph 1, if the adult guardian has not brought an action of denial of paternity, the adult ward may bring the action of denial of paternity within 2 years after the adjudication on the termination of adult guardianship is made. This article wholly amended by Act No. 10429, March 7, 2011. Article 849, Denial of Paternity after Death of Child. If any lineal descendant of a child survives after the death of the child, the husband may bring an action of denial against the child's mother, or if the mother does not survive, against the public prosecutor. Article 850, Denial of Paternity by Will. If the husband or wife has expressed an intention of denial of paternity by will, the executor of the will shall bring an action of denial of paternity. Less than amended by Act No. 7427, March 31, 2005 greater than. Article 851, Death of husband before birth of child, etc. and denial of paternity. If the husband dies before the birth of a child or the husband or wife dies within the period mentioned in Article 847, 1. Only the lineal ascendant or lineal descendant of the husband or wife may bring an action of denial of paternity within 2 years from the day on which he or she becomes aware of the death. This article wholly amended by Act No. 7427, March 31, 2005. Article 852, Extinction of Right of Denial of Paternity. Any person who recognizes the paternity of a child after the child is born may not bring an action of denial of the paternity again. This article wholly amended by Act No. 7427, March 31, 2005. Article 853 deleted. Less than by Act No. 7427, March 31, 2005 greater than. Article 854, Revocation of recognition caused by fraud or duress. Recognition mentioned in Article 852 caused by fraud or duress shall be revocable. Less than amended by Act No. 7427, March 31, 2005 greater than. Article 855, Affiliation. 1. A child born out of wedlock may be affiliated by its natural father or mother. When the marriage of the parent becomes null and void, the child born between them shall be deemed to be a child born out of wedlock. 2. A child born out of wedlock, when its father and mother marry, shall be deemed to be a child born during the marriage from the time of the marriage. Article 856. Affiliation by adult ward. If a father is an adult ward, he may affiliate himself as being the father of his child with the consent of the adult guardian. This article wholly amended by Act No. 10429, March 7, 2011. Article 857. Affiliation of deceased child. Even after a child has died, if its lineal descendant survives, it may be affiliated as the lawful child. Article 858. Affiliation of unborn child. A father may affiliate an unborn child. Article 859. Effectiveness of affiliation. 1. Affiliation shall become effective when it is reported in accordance with the provisions of the Act on the Registration, etc. of Family Relationship. Less than amended by Act No. 8435, May 17, 2007. Greater than. 2. Affiliation may be effected by a will. In this case, the executor of a will shall make such report. Article 860. Retrospective effect of affiliation. Affiliation shall be retrospectively effective from the time of birth of the child, provided that the right acquired by a third person shall not be prejudiced thereby. Article 861. Revocation of affiliation. If affiliation has been made by fraud, duress, or grave mistake, its revocation may be claimed to the family court within 6 months from the day when such fraud or mistake becomes known, or such duress disappears. Less than amended by Act No. 7427, March 31, 2005. Greater than. Article 862. Action of demurrer against affiliation. A child or any other person interested may bring an action of demurrer against an affiliation within 1 year from the day when it becomes aware of a report of such affiliation. Article 863. Action demanding affiliation. A child, any of its lineal descendants, or the legal representative of any of them, may bring an action against its father or mother demanding affiliation by its father or mother. Article 864. Death of father or mother and action demanding affiliation. In the cases mentioned in Articles 862 and 863, if the father or mother of a child has died, an action of demurrer or action demanding affiliation may be brought against the public prosecutor within 2 years from the day when the death of the father or mother becomes known. Less than amended by Act No. 7427, March 31, 2005. Greater than. Article 864-2. Affiliation and responsibility of fostering child, etc. The provisions of Articles 837 and 837-2 shall apply mutatis mutandis with respect to the responsibility of fostering a child and the visitation right in the case of the affiliation of the child. This article newly inserted by Act No. 7427, March 31, 2005. Article 865. Action demanding confirmation of denial or existence of paternity due to any other reasons. 1. A person who may bring an action in accordance with the provisions of Articles 845, 846, 848, 850, 851, 862 and 863, may bring an action demanding confirmation of denial or the existence of paternity for any reason other than those mentioned in the aforesaid articles. 2. In the cases mentioned in paragraph 1, if the party concerned has died, the other party may bring an action against the public prosecutor within 2 years from the day when it becomes aware of such death. Less than amended by Act No. 7427, March 31, 2005. Greater than. Section 2. Adopted children. Subsection 1 Requisites for and effective adoption. Article 866 Capacity for adoption. Anyone who has attained majority may adopt another as his/her child. This article wholly amended by Act No. 11,300, February 10, 2012. Article 867 Permission from Family Court for adoption of minor. 1. Anyone who intends to adopt a minor shall obtain permission from the family court. 2. The family court may choose not to grant permission under paragraph 1, for the sake of the welfare of a minor to be adopted, taking into consideration the situation of the minor's fostering, the motives of such adoption, the prospective parent's competence for fostering the minor, and other circumstances. This article newly inserted by Act No. 11,300, February 10, 2012. Article 868 deleted. Less than by Act No. 4199, January 13, 1990 greater than. Article 869, Declaration of Intent to Adopt. 1. If a person to be adopted is a minor of at least 13 years of age, the adoption shall be granted with the consent of his/her legal representative. 2. If a person to be adopted is a minor under 13 years of age, his/her legal representative shall permit the adoption on his/her behalf. 3. In any of the following circumstances, the family court may permit adoption under Article 867, 1, even if the consent under paragraph 1, or the permission under 2, has not been obtained. 1. Where the legal representative refuses to give his/her consent or permit without any just ground, provided that where the legal representative is the person with parental rights, he/she shall fall under any cause prescribed in Article 872. 2. Where the consent or permission is unable to be obtained due to the unknown whereabouts of the legal representative or by any other cause. 4. In cases falling under paragraph 3(1), the family court shall examine the legal representative. 5. The consent under paragraph 1, or the permission under paragraph 2, may be withdrawn before the adoption is permitted under Article 867, 1. This article wholly amended by Act No. 11,300, February 10, 2012. Article 870, Parents' Consent to Adoption of Minor. 1. The adoption of a minor shall require consent of his/her parents, provided that the same shall not apply in any of the following circumstances. 1. Where the parents have given consent under Article 869, 1, or permission under Article 869, 2. 2. Where the parents have been declared to lose parental authority. 3. Where he/she has not been able to obtain consent from his/her parents due to the reasons such as the unknown whereabouts of the parents, etc. 2. Even if the parents refuse to give their consent, the family court may permit adoption under Article 867, 1, where any of the following causes arises. In such cases, the family court shall examine the parents. 1. If the parents have failed to perform their duty to foster the child for at least 3 years. 2. If the parents have abused or deserted the child or otherwise have severely impaired the welfare of the child. 3. The consent referred to in paragraph 1 may be withdrawn before the permission for adoption is granted under Article 867, 1. This article wholly amended by Act No. 11,300, February 10, 2012. Article 871, Consent from Parents for Adoption of Adult. 1. The adoption of an adult shall require the consent of his/her parents, provided that the same shall not apply where the consent is unable to be obtained due to the reasons such as the unknown whereabouts of the parents. 2. If the parents refuse to give their consent without any justifiable ground, the family court may make an adjudication substituting for the consent of the parents upon the application of a prospective adoptive parent or adopted child. In such cases, the family court shall examine the parents. This article wholly amended by Act No. 11,300, February 10, 2012. Article 872 deleted. less than by Act Number 11,300, February 10, 2012, greater than. Article 873, Adoption of Adult Ward. 1. An adult ward may, upon the consent of his/her guardian, adopt a child or may be adopted by another. 2. Article 867 shall apply mutatis mutandis where an adult ward adopts a person or becomes an adoptee. 3. If an adult guardian refuses to give consent referred to in paragraph 1, or if the parents of the adult ward refuse to give consent referred to in Article 871, 1, without any justifiable ground, the family court may grant permission for the adoption even without such consent. In such cases, the family court shall examine the parents. This article wholly amended by Act Number 11,300, February 10, 2012. Article 874, Joint Adoption by Husband and Wife. 1. When a person who has a spouse adopts a child, he/she shall do so jointly with his/her spouse. 2. When a person who has a spouse is adopted, he/she shall obtain the consent of the spouse. This article wholly amended by Act Number 11,300, February 10, 2012. Article 875 deleted. Less than by Act Number 4199, January 13, 1990, greater than. Article 876 deleted. Less than by Act Number 4199, January 13, 1990, greater than. Article 877, Prohibition of Adoption. No ascendant or person of elder age shall be adopted. This article wholly amended by Act Number 11,300, February 10, 2012. Article 878, Formation of Adoption. An adoption shall take effect when it is reported, as prescribed by the Act on the registration, etc. of family relationship. This article wholly amended by Act Number 11,300, February 10, 2012. Articles 879 and 880 deleted. Less than by Act Number 4199, January 13, 1990, greater than. Article 881, Examination of Adoption Reports. An adoption report shall be accepted unless the adoption is in violation of Articles 866, 867, 869 through 871, 873, 874, 877 and any other acts and subordinate statutes. This article wholly amended by Act Number 11,300, February 10, 2012. Article 882, Adoption Reports in Foreign Country. Article 814 shall apply mutatis mutandis to the filing of an adoption report in a foreign country. This article wholly amended by Act Number 11,300, February 10, 2012. Article 882-2, Effect of Adoption. 1. An adopted child shall have the status equal to that of a natural child of the adoptive parent from the time he/she becomes an adoptee. 2. The kinship of an adoptee shall continue to exist even after the adoption. This article newly inserted by Act Number 11,300, February 10, 2012. Subsection 2, Nullity and annulment of adoption. Article 883, Causes for nullity of adoption. An adoption shall be null and void in any of the following circumstances. 1. Where the parties have not agreed on the adoption. 2. Where the adoption is in violation of Article 867, 1, including the cases applied mutatis mutandis under Article 873, 2, 869, 2, or 877. This article wholly amended by Act Number 11,300, February 10, 2012. Article 884, Causes for annulment of adoption. 1. If an adoption falls under any of the following cases, a claim for annulment may be made to the family court. 1. Where the adoption is in violation of Articles 866, 869, 1, or 32, 870, 1, 871, 1, 873, 1, or 874. 2. Where there is no knowledge of the fact, at the time of adoption, that either of the adoptee or the adoptive parent has been suffering from a malignant disease or has had any other serious cause. 3. Where an intent to adopt was expressed by fraud or duress. 2. Article 867, 2, shall apply mutatis mutandis to the annulment of an adoption. This article wholly amended by Act Number 11,300, February 10, 2012. Article 885, Claimants for annulment of adoption. The adoptive parent, adopted child or his/her legal representative or lineal blood relative may claim annulment of the adoption made in violation of Article 866. This article wholly amended by Act Number 11,300, February 10, 2012. Article 886, Claimants for annulment of adoption. An adoptee or a person entitled to give consent to the adoption may claim annulment of the adoption made in violation of Article 869, 1, or 32, or 870, 1, and a person entitled to give consent to the adoption may claim annulment of the adoption made in violation of Article 871, 1. This article wholly amended by Act Number 11,300, February 10, 2012. Article 887, Claimants for annulment of adoption. An adult ward or adult guardian may claim annulment of the adoption made in violation of Article 873, 1. This article wholly amended by Act Number 11,300, February 10, 2012. Article 888, Claimants for annulment of adoption. The spouse may claim annulment of the adoption made in violation of Article 874. This article wholly amended by Act Number 11,300, February 10, 2012. Article 889, Extinction of right to claim for annulment of adoption. No claim shall be made for annulment of the adoption made in violation of Article 866, if the adoptive parents reach their majority. This article wholly amended by Act Number 11,300, February 10, 2012. Article 890 deleted. Less than by Act Number 4199, January 13, 1990 greater than. Article 891. Extinction of right to claim for annulment of adoption. 1. If 3 months elapse after an adoptee has attained majority or if an adoptee dies, no claim for annulment of the adoption made in violation of Article 869, 1, or 32, or 870, 1, shall be made. 2. If an adoptee dies, no claim for annulment of the adoption made in violation of Article 871, 1, shall be made. This article wholly amended by Act Number 11,300, February 10, 2012. Article 892 deleted. Less than by Act Number 11,300, February 10, 2012 greater than. Article 893. Extinction of right to claim for annulment of adoption. If 3 months elapse after the commencement of adult guardianship has been revoked, no claim for annulment of the adoption made in violation of Article 873, 1, shall be made. This article wholly amended by Act Number 11,300, February 10, 2012. Article 894. Extinction of right to claim for annulment of adoption. If the adoption is in violation of Article 869, 1, or 32, 870, 1, 871, 1, 873, 1, or 874, no claim for annulment may be made after 6 months lapse from the day the adoptive parent becomes aware of the cause thereof, or after 1 year lapses from the day the cause thereof arises. This article wholly amended by Act No. 11,300, February 10, 2012. Article 895 deleted. Less than by Act No. 4199, January 13, 1990 greater than. Article 896. Extinction of right to claim for annulment of adoption. No claim for annulment of the adoption that falls under any cause prescribed in Article 884(1)(2) shall be made, if 6 months elapse from the day either the adoptive parent or adoptee becomes aware of the cause thereof. This article wholly amended by Act No. 11,300, February 10, 2012. Article 897. Provisions to be applied mutatis mutandis. Article 806 shall apply mutatis mutandis to the claims for damages from the nullity or annulment of adoption. Article 823 to the extinction of the right to claim annulment of adoption made by fraud or duress. Article 824 to the effect of annulment of adoption. This article wholly amended by Act No. 11,300, February 10, 2012. Subsection 3. Dissolution of adoptive relation. Article 898. Dissolution of adoptive relation by agreement. The adoptive parent and the adoptee may, by agreement, dissolve the adoptive relation, provided that same shall not apply where the adoptee is a minor or adult ward. This article wholly amended by Act No. 11,300, February 10, 2012. Article 899 deleted. Less than by Act No. 11,300, February 10, 2012 greater than. Article 900 deleted. Less than by Act No. 11,300, February 10, 2012 greater than. Article 901 deleted. Less than by Act No. 11,300, February 10, 2012 greater than. Article 902. Dissolution of adoptive relation by agreement for adult ward. The adoptive parent who is an adult ward may enter into a consultation for dissolution of adoptive relation upon the consent of the adult guardian. This article wholly amended by Act No. 11,300, February 10, 2012. Article 903. Examination of reports on dissolution of adoptive relation. A report on dissolution of the adoptive relation shall be accepted unless the dissolution is in violation of Article 898, 902 or any other acts and subordinate statutes. This article wholly amended by Act No. 11,300, February 10, 2012. Article 904. Provisions to be applied mutatis mutandis. Article 823 shall apply mutatis mutandis to the extinction of the right to claim the annulment of adoption by fraud or duress, and Article 878 shall apply mutatis mutandis to the formation of dissolution of adoptive relation by agreement. This article wholly amended by Act No. 11,300, February 10, 2012. Article 905. Causes for judicial dissolution of adoptive relation. The adoptive parent, the adoptee or a person entitled to claim under Article 906 may claim for dissolution of adoptive relation in any of the following circumstances. 1. If the adoptive parent has abused or deserted the adoptee or otherwise has severely impaired the welfare of the adoptee. 2. If the adoptive parent has been extremely maltreated by the adoptee. 3. If the death or life of the adoptive parent or adoptee has been unknown for at least 3 years. 4. If there exists any other serious cause making it impracticable to continue the adoptive relationship. This article, wholly amended by Act No. 11,300, February 10, 2012. Article 906. Person entitled to claim for dissolution of adoptive relation. 1. If an adoptee is under 13 years of age, the person who has given permission under Article 869. 2. May claim for the dissolution of adoptive relation on behalf of the adoptee, provided that if there is no person entitled to claim dissolution of adoptive relation, a relative of the adoptee prescribed in Article 777 or an interested person may make a claim therefor. 2. If an adoptee is a minor who is at least 13 years of age, the claim for dissolution of adoptive relation may be made with the consent of the parents who have given the consent under Article 870. 1. Provided that if the parents have died or if the parents are unable to give such consent due to any other cause, the claim for dissolution of adoptive relation may be made without such consent. 3. If the adoptive parent or adoptee is an adult ward, the claim for dissolution of adoptive relation may be made with the consent of the adult guardian. 4. A public prosecutor may claim for the dissolution of adoptive relation for an adoptee who is a minor or adult ward. This article wholly amended by Act No. 11,300, February 10, 2012. Article 907. Extinction of right to claim for dissolution of adoptive relation. No person entitled to claim for the dissolution of adoptive relation shall claim for the dissolution of adoptive relation, if 6 months elapse from the day the person becomes aware of any cause prescribed in subparagraph 1, 2 or 4 of Article 905, or if 3 years elapse from the day such cause arises. This article wholly amended by Act No. 11,300, February 10, 2012. Article 908. Provisions to be applied mutatis mutandis. Article 806 shall apply mutatis mutandis to the claims for damages from the judicial dissolution of adoptive relation. This article wholly amended by Act No. 11,300, February 10, 2012. Subsection 4. Full adoption. Article 908-2. Requisites, etc. for full adoption. 1. Any person who intends to make the full adoption of a child shall make a request to the family court for such full adoption upon meeting all of the following requirements. 1. The adoption shall be made jointly by the husband and wife who have been married for at least 3 years, provided that this shall not apply where either of the husband and wife who have been married for at least 1 year or more makes the full adoption of the other spouse's child as his or her one. 2. A child to be fully adopted shall be a minor. 3. Consent to such adoption shall be obtained from the natural parents of a child to be fully adopted, provided that the same shall not apply if the parents are unable to give consent due to the declaration of the loss of parental authority, unknown whereabouts of the parents, or by any other cause. 4. If a child to be fully adopted is at least 13 years of age, the adoption shall be permitted with the consent of the child's legal representative. 5. If a child to be fully adopted is under the age of 13, the child's legal representative shall permit the adoption on behalf of the child. 2. The family court may accept the claim made under paragraph 1, even without the consent paragraph 1(3) or 4 or the permission paragraph 1(5) in any of the following circumstances. In such cases, the family court shall examine the person entitled to consent or permission. 1. Where the legal representative refuses to give consent or permission without any just ground, provided that if the legal representative is a person of parental authority, she shall have any cause referred to in subparagraph 2 or 3. 2. Where the natural parents have failed to perform the duty to foster the child or to exercise the visitation right for at least 3 years due to a cause attributable to themselves. 3. Where the natural parents have abused or deserted the child or otherwise have severely impaired the welfare of the child. 3. The family court may reject the request made under paragraph 1, if such full adoption is deemed inappropriate for the welfare of the child to be adopted, taking into consideration the situation of the child's fostering, the motives of such full adoption, the prospective adoptive parent's competence for fostering the child, and other circumstances. This article wholly amended by Act No. 11,300, February 10, 2012. Article 908-3, Effect of Full Adoption. 1. The child adopted through full adoption shall be deemed to be born during the marriage of the adoptive parents. 2. The kinship of the adopted child before such full adoption shall be terminated at the time such full adoption is decided upon a request made under Article 908-2. 1. Provided that where one of husband and wife has made the full adoption of the other spouse's child as his or her one independently, the same shall not apply with respect to the relationship of the child with the other spouse and the other spouse's relatives. This article newly inserted by Act No. 7427, March 31, 2005. Article 908-4, Annulment, etc. of full adoption. 1. If the natural father or mother of a child to be fully adopted through full adoption fails to give consent referred to in the proviso to Article 908-213 due to any cause not attributable to himself, herself, she may make a request to the family court for annulment of such full adoption within 6 months from she becomes aware of such adoption. 2. Articles 883 and 884 shall not apply to full adoption. This article wholly amended by Act No. 11,300, February 10, 2012. Article 908-5, Dissolution of full adoption. 1. The adoptive parent, adopted child, natural father or mother, or public prosecutor may apply to the family court for the dissolution of the full adoption in any of the following circumstances. 1. Where the adoptive parent has abused or deserted the adopted child or otherwise has severely impaired the welfare of the adopted child, and 2. Where it is impossible to maintain the relation of the full adoption due to any act of immoral conduct which the adopted child has committed against the adoptive parent. 2. The provisions of Articles 898 and 905 shall not apply with respect to the dissolution of full adoption. This article newly inserted by Act No. 7427, March 31, 2005. Article 908-6, Provisions to be applied mutatis mutandis. Article 908-2, 3, shall apply mutatis mutandis to the annulment of full adoption or the request for dissolution of full adoption under Article 908-512. Less than amended by Act No. 11,300, February 10, 2012 greater than. This article newly inserted by Act No. 7427, March 31, 2005. Article 908-7, Effect of annulment and dissolution of full adoption. 1. If a full adoption is annulled or dissolved, the adoptive relation shall be terminated and the relationship of relatives before such full adoption shall be re-established. 2. In cases falling under paragraph 1, the annulment of full adoption shall not be effective retroactively. This article newly inserted by Act No. 7427, March 31, 2005. Article 908-8, Provisions to be applied mutatis mutandis. Except as otherwise expressly provided for in this subsection, the provisions concerning adoption shall apply mutatis mutandis to full adoption unless they are contrary to the nature of such full adoption. This article newly inserted by Act No. 7427, March 31, 2005.